While Washington sits on edge with another possible government shutdown staring us right in the face, we stare down the legal matters that will truly shape this nation from the Supreme Court. Welcome to another issue of Obamacare on Trial, and examine the words that could make all the difference. Let's also welcome back our legal analyst from the law offices of O'Brien and Ryan LLP in Philadelphia, Heather Hansen. Hi, Heather. Good to see you again.
Good to see you, Ed.
Here we go again. I'm sorry, but you have to kind of say that because you had to lighten up a little bit because I realize it's a very important ruling that's coming up here, but we have talked about this and talked about this. Now we are finally here. King versus Burwell. What are the things that we need to focus on as we watch this happen here over the next several days, weeks, and months, Heather?
It's 4 words, Ed. It really comes down to 4 words. As you know, this statute is huge and it's unwieldy, and many of the people who wrote it never took the time to read it. But there are 4 words in there which says that the exchanges that are established by the states are not to get federal subsidies. Those 4 words, established by the states, are going to be the issue of the arguments that are coming up this week, because the plaintiffs in this case say that if the exchanges are not established by the states, and the majority of them are not, that they can't be funded by federal subsidies, which means that they will go up in smoke. And the result of that we have yet to determine, but could well be that a lot of people lose their insurance.
Now, if indeed the Supreme Court finds, let's just say, and again, we have to set this up for people, they find that those words do indeed indicate a violation, if you will, an overreach by Obamacare. Once the Supreme Court issues this decision, what then would be next? Because let's face it, the Obama administration is not going to give up.
The people who are receiving health care through Obamacare in the states that don't have exchanges established would then lose their insurance, arguably. Now listen, no one really wants that to happen. Even Republicans who are against Obamacare don't want that to happen. You saw some senators yesterday write an op-ed saying that they're putting something into place to serve as a transition period so that that won't happen. So ultimately, I think that whether it's judicial or congressional, we will find what Paul Ryan has called a bridge to make sure that those people don't lose insurance. But the concern is real, and I think that the administration is trying to make sure that the justices know that that concern is real, so that they have it in their minds when they're making the decision about what Congress meant with those 4 words.
So here comes the easy part for people then, at least to help them understand. If indeed the Supreme Court finds against Obamacare, a lot of people may lose their insurance. There's going to be some sort of a bridge that will be created. That could take time. So isn't it then just a possibility that there are going to be people out there who believe they have insurance, paying for it, but they are going to be left completely high and dry for a short period of time?
That is possible, although the likelihood is that the justices will allow for some transitional time. No one wants that to happen. So between Congress, the justices, and the administration, it is optimistically hoped that that won't happen.
Okay. We'll all remain optimistic then for a while, because here we go. It's just going to get even worse here as we go through the next couple of weeks. About 90 seconds left before we take a break. Come back here. A federal judge has struck down Nebraska's ban on same-sex marriage. It would seem to be yet again another indication that states who have bans on same-sex marriage, it is going to go the way of the dodo sooner or later.
You know, you would think so, Ed, but this is especially interesting because this same judge struck it in 2005, and the appeals court for that area, the 8th Circuit, reinstated it. So this case is going to go up. We know that the 6th Circuit has already said that the bans are legal, which is why it's going to the Supreme Court. You may see the 8th Circuit do the same thing, which makes the Supreme Court decision in the spring all the more important.
If indeed, and it will, it's going to go to the Supreme Court. We understand that. But if and when it reaches there, Heather, this is going to sound like a strange question to ask, but would that really be the last say on all this? Because the Supreme Court issues a ruling, we have seen things challenged still for decades.
Yeah, it will be. The reason we've seen this continue to be challenged is because they never issued the last word. I think the Supreme Court, the last time they looked at this, really wanted the states to sort of come to this decision on their own. That has not happened. It's caused enough problems that they're looking at it again, and it will be the last word, despite what some lawmakers want to try to do. It will be the last word.
Okay, I'll tell you what, we're going to put that down in stone. We're going to put that right now. We're going to have that down. It will
Hold me to it.
It will be the last word. Okay.
That's right.
Boy, We hope, but then again, that's just the way politics works. See, I got to put the caveat in there because I am not an attorney, but I play one on TV, which means I know exactly. You've always got to put the escape clause in there. All right, hang on just a couple of seconds here, Heather. From the heartland of America comes that decision, but this time, let's dig a little deeper into some of the other things that are happening right now. For instance, race concerns and crime suspects and descriptions. That and so much more coming up as we dig inside the law right here on MidPoint. Court is back in session. All eyes toward our legal analyst from the law offices of O'Brien and Ryan LLP in Philadelphia. Heather Hansen joins us again. All right, Heather, here we go. The Boston bomber trial. The openings are tomorrow. And you wish these were televised, don't you?
Oh, I really do. I mean, I think that you're going to see some really good lawyering, some very dramatic openings, and also just a real outline of what to expect over the next months as far as what evidence is going to be presented and what the defense is going to do here.
Do you think, as some people have indicated, that they may walk into court and plead guilty?
You know, there's an argument to be made to do that. You never want to lose credibility with the jury, so you don't want to make an argument that you know is a loser. And it seems as though even with these jurors have said they're inclined to believe that he did it. I wouldn't do it in this case, and I don't think they're going to do it in this case for a couple of reasons. One is that if you give the jurors the satisfaction of finding him guilty, they may be less inclined to send him to death. Another is that over the course of this trial, as they contest liability, they can also sort of play it out to show that he had some human qualities, that his brother was the driving force, that he wasn't the one behind all of that, which again, the end game here, Ed, is to save his life. So anything they can do towards that end, they're going to try to do.
Well, here's someone they say that did not have human qualities. 18-year-old Michelle Carter, she's a Plainville teenager in New England, urging a friend to kill himself last summer, claiming she helped him research how to die from carbon monoxide poisoning and told him to get back in his truck when he had second thoughts. This is wildly cold if this is what she really did.
Oh, it's horrible. And there are thousands of text messages that support that this is what she did. She is most certainly morally reprehensible. This case is a stretch of the law. She's not being charged with any sort of cyberbullying, cyber terrorism, anything like that. She's being charged with involuntary manslaughter. You don't often see cases where someone who encourages someone else to do something like this is in charge with involuntary manslaughter. It's almost like assisted suicide or a contract killing where somebody gives someone the means to kill themselves. But it's a stretch of the law, which will be interesting to see how it plays out.
Here's another differences in the law, too. The University of Minnesota no longer includes race and other descriptions of suspects in email crime alerts unless there's enough detail to aid in an arrest. That sort of seems like they're kind of trying to hit both sides here, because if you have a suspect and if you have a white male or a black female or whatever, right, wouldn't you necessarily have to put that in the description?
You would think so. I mean, this just seems to me to be going way too far in the name of political correctness. What happened is federally, these colleges and universities have to put out these types of warnings. And many minorities had objected and said that it sets them up for being suspicious, having people be suspicious of them for no good reason. And if all you have as a description is that it's an African American male or an Asian female, that's not enough. I think ultimately the university is going to regret this decision, because they're going to decide this now by a case-by-case basis, and to take the extra time to determine, well, is it good enough that we give this racial description as well as everything else? You're taking time away from people actually catching the suspects. So I think it's a bad, bad decision in the name of political correctness.
And one last thing here, about a minute or so that we have left, a cellular tracking case, a device that apparently the defense team found that investigators had used a secret surveillance tool to catch a couple of criminals. What would be wrong with that?
You know, it's really going to be something that we're going to see a whole lot more often. There are these things called stingrays that the government is using to track people's locations. And these stingrays are used by federal government officials and local government officials. The federal government officials so much don't want people to know about this that when the local government officials use them, they can't release information about them and often have to enter into pleas so that they don't have to release information about them. Whether or not it is legal to track someone by their cell phone is something that is soon going to be decided by the various appellate courts, and I believe will ultimately go up to the Supreme Court.
And once again, we're heading right back for the Supreme Court, which means we'll have a lot more time to talk about the folks up there, and they'll say, we don't know, we'll get to it next time. There you go. And next time we'll talk about more legal. Heather Hansen, always a pleasure. Good seeing you again.
Thanks, Ed. Good to see you. Have a great day.
Take care. You too. In what may be a sad commentary on our society, join me next for Proof Positive. There is never anything difficult about finding a collection of the brain-addled here in America, especially when it comes to politics. Next on MidPoint.